That was fun. I will call this meeting to order on the Children and Youth and Families Committee. Thank you all for being here, and we do indeed have a quorum. Now, I'm very excited to chair this committee. This is very near and dear to my heart. And I have one baby and another one on the way. When I was on this committee a little while ago, I had 0 children and was unmarried, which I did not understand why I was there. Short time later, now I very much understand why I'm here, and it's incredibly excited to get started on this work. We're gonna have a good time on this committee. We're gonna be nice. We're gonna be civil. When our counterparts from the other party show up, we will continue to be nice and civil. And hopefully today we can all learn from the immense wisdom of our nonpartisan staff. And people who do not know our nonpartisan staff might think that was a sarcastic comment, but the second you work with them, you will realize, thank God they are here. So, without further ado, what we want to cover today is the jurisdiction of the committee. This committee does have over $1 billion under its jurisdiction through its various state and federal programs, and we have a new department that we need to provide very important oversight to. So, with that in mind, it is time to learn the committee. Now, you might go, why are we not doing introductions? We're going to save introductions until our colleagues come here, because we all know each other. We know nonpartisan staff. When our colleagues from the other side of the aisle decide to show up, we will have a wonderful intro that will be heartwarming and wonderful, and we'll get to work. But in the time being, it's time to learn, and I will turn it over to whichever member of the nonpartisan staff will kick us off.
Thank you, Mr. Chair. I'm Annie Mock with House Research, and my colleagues and I are going to give you an overview of the committee's jurisdiction. So just to let you know what we're going to go over, we're going to describe our nonpartisan staff roles, and then Mr. Berg is going to go over the budget. Ms. Pinelli is going to go over economic assistance programs and employment supports. Ms. Sunderman will go through child support, child welfare and placement. And then I'm going to cover child care licensing, subsidies for child care, early learning programs, and child care workforce programs. So we are all nonpartisan staff. Mr. Berg is with House Fiscal, Ms. Pinelli, Ms. Sunderman, and I are with House Research. You can see the different roles we have there on the screen. You should know we all work very closely together, and we kind of operate under a no wrong door policy. So if you ever have questions or requests, you can contact any of us, and we'll make sure you get to the right person. The chair just mentioned the Department of Children, Youth, and Families, one of the newest state agencies. Most of the programs that are in that new agency's jurisdiction are in this committee's jurisdiction. So this committee will interface with that new agency quite often. The agency was created by the 2023 legislature. It was actually established July 1st of 2024 with a commissioner appointed. And since July of 2024, various programs from DHS, DPS, MDH, and MDE have transferred over to the new agency. At this point, most programs that are set to transfer have transferred, although there are a few that are still going to move later this year. As part of establishing that new agency, nonpartisan staff were directed to recodify statutes to reflect the transfer of all the programs and duties to DCYF. It was a big recodification. There was a lot of movement of statutes. So if you ever get confused with statute because you used to know where something was and you don't know where it is anymore, there is a resource on HRD's website that Ms. Punelli put together that actually crosswalks the old statutes with the new statutes. So that's very useful. And with that, I'm going to hand it over to Mr. Berg.
Mr. Berg.
Mr. Chairman, members, I'm Doug Berg with the House Fiscal Staff, and I'll be staffing this committee as well as the HHS committee. Piggybacking on what Ms. Mock said about the reorganization of state government, I'm just going to start with for the budget accounts. And I won't go through this in detail, but what you have here is on the left side, you have for the upcoming biennium, fiscal years 26 and 27, these are the programs and budget activities that this committee will be dealing with at DCYF. And on 24-25, it tells you where those came from. And for the most part, you'll see that they come from DHS straight up, although there are a few in the admin area where it's a blend of DHS funds and MDE funds, or in the case of Economic Opportunity and Youth Services, DHS and public safety funds. It goes on to the next page where you'll see the grant programs, which mostly came from DHS, although the early learning grants were transferred over from Department of Education. And there are some youth services grants that were formerly at the Department of Public Safety. All right, starting with the very biggest picture here, this is the all funds budget for, base budget for this committee for the next 2 years by fund. And the top one is the general fund, and as the chairman knows and other members who have been here, we will spend almost all our activity on the general fund. However, there is a lot of other money here. The general fund base is a little over $2 billion for 2 years for this committee. The second line there, I'll just note, child support enforcement, it's a lot of money, but that is in fact child support dollars, which the agency is a party to most child support cases. And they actually perform the function of collecting the money and distributing it to who it goes to. You'll see in a minute that our actual appropriation for child support is negligible. This is actually just money to be distributed to the parties who are entitled to it. TANF is a big chunk of this committee. It comes in 2 programs, the MFIP Child Care and the MFIP Cash Grant DWP program. And then you'll see the largest chunk is the federal fund. Almost all of that is the federal SNAP program. There is, this is almost all food support, and of that, it's almost all SNAP. SNAP is an entirely federally funded program. The benefit, there's no state money in the benefit. So while this is a huge amount of money, it's something that we really won't be doing anything with because it's set for what it does. The other things, as you go down, there's a very small piece of the opioid epidemic response fund in here that comes into the child protection area, and the others are miscellaneous revenue accounts. This then, now we're moving from the all funds down to the general fund, and this is the committee base by program. And if you look, the upper part of this is the Department of Children, Youth, and Families. The program levels are sort of the type of appropriation. And you'll see it, Children, Youth, and Families, there's operations and administration. That's kind of the administration of all the grants in the agency itself. Forecasted programs, and I'll get into a little more detail in the next slide about what these are, but forecasted programs, which are in each revenue forecast, there will be a new number in February when we get a new forecast. These programs will change what we expect them to cost at that point. And as I say, I'll go into what those are specifically on the next set of slides. And then there are grant programs. Grant programs, typically the amount you appropriated last year, less the second year of the biennium, that is the current fiscal year, less any one-time appropriations. That's the base that rolls forward. So if you had $1 million grant base and there was no change to it, it's $1 million in fiscal 25 and $1 million in 26, or 26 and 27. Usually they don't change except to remove one-time funding. At the bottom, you'll see there are a couple of small accounts that are in this area, in this committee. The Ombudsperson for Families, the Ombudsperson for American Indian Families, and the Ombudsperson for Foster Youth are all part of this. They only have one line here because as a small agency, they don't have more than one program. That just their whole program is their budget. I will note on here there is, if you compare this slide to the next one, there is a slight discrepancy on the the fiscal year 27 and fiscal year 29 columns where you wouldn't notice this unless I told you, but it is somehow double counting the operations number. So the bottom line number here is not quite correct on the total for the committee. You'll see the correct number on the next page. So taking that same level of general fund base only down to what we call the budget activity level, which is the level at which the legislature appropriates funds. You'll see on slide 10 that operations and administration at the Department of Children, Youth, and Families each agency has a slightly different name. In this case, they call it agency-wide support, so that is administration across the agency, child safety and permanency administration. There's a note that one with the statutory site I will just mention as for newer members. This is a statutory appropriation for administration of ICWA compliance. ICWA is the Indian Child Welfare Act. The main reason I would draw this to your attention is to get members to understand the difference between a statutory appropriation and a direct appropriation. We won't put this number into our bill because the statute already says that $390 million a year goes to the department for administration of ICWA. Other things I'm talking about are what we call direct appropriations. Those will be on the spreadsheet and will show up in the bill as a number we appropriate. We don't have too many statutory appropriations, but that one is here. As you see at the bottom, the total base for administration is about $274 million a biennium. Go down to the next set is forecasted programs. There are 3 that are in the purview of this committee at this point. The MFIP DWP program, that is the Minnesota Family Investment Program, and you can think of this as the cash grant portion of that. The DWP, which stands for Diversionary Work Program, that is actually being repealed in 2026. The 23 legislature repealed the Diversionary Work Program part of the cash grant. Below that, you'll see is the MFIP Child Care Assistance Program, and then North Star Care for Children, which is a forecasted program that deals with foster care, kinship assistance, and adoption assistance. Those you'll see is about $700 million a biennium is the base for those programs. But again, all of those programs will change in the February forecast. They may go up or down. Going to the next page, you've got the third grouping of types of programs at DCYF, which are grant programs. These are all the grants that came over from mostly Department of Human Services, but in a few cases, Department of Ed or MDH or Department of Public Safety. That's about $1.2 billion of grant programs is the base for the upcoming biennium. And then again, you'll see the smaller accounts at the bottom. One thing I will note on here is there is a hidden line which shouldn't be hidden. There is another grant program which should show up between Child and Economic Support grants and Youth Services grants. Those are early learning grants. The numbers are in here, so all the numbers on this page are correct, and the bottom line is correct for this committee's base, but it just doesn't show the early learning grants there. And you'll see on the bottom line that the total base for this committee general fund base is $2,126,259,000. That again will change in the February forecast. The only other thing I would note about this is you will see about the 6th line up, there is a negative number, which is called DCYF federal reimbursement. In this committee and also in Human Services, there is a thing which is referred to as FFP, Federal Financial Participation. And in many administrative appropriations, the federal government will pay a portion of the cost, usually 32%, although there are a couple of other situations, but usually 32%. So if you're doing something that, you know, adds an administrative employee or something like that, it often will be a third of it will be reimbursed by the federal government. That number is taken off as an offset to the expenditure in this committee for the Department of Children, Youth, and Families. Same thing happens over in HHS for DHS. And if you look at the general fund balance, you've got the appropriation to the agency minus the amount that we get in from federal funds participation to get to the net impact. Now, that's very different from those who might be familiar with the HHS committee, what we call FMAP. That is a different thing entirely, and it represents much, much, much more money. But here, you see it's estimated to be $38 million offset in 26, 27. Decisions that you all make, some of them will include FFP and will account for that on the spreadsheet so that we know what the net general fund expenditure is before the bill passes. And Mr. Chair, I think that's all I have to say about the base budget at this point.
Perfect, right there. Representative Nadeau.
Thank you, Mr. Chair. And just one question, Mr. Berg. Is that FFP number, is that also a forecasted number that will change with the forecast? Or is that based on past decisions?
It's not exactly one or the other. The answer is that it will probably not change at all. They make an estimate of that as we do each of these things. Sometimes it's not right. When a forecast comes out, they will adjust it. But this is based on things that have been done for which the federal reimbursement applies. And so it shouldn't change. There can be situations where, again, you know, maybe for reasons, you know, a grant program doesn't, well, it wouldn't be a grant program. Something happens at the administrative level where we're not doing something that we had projected, and so then it would come out, but typically it does not change much in a forecast.
Representative Nadeau.
And one final question was, with the elimination of the diversionary work program, is there significant changes in that financial line item in this budget moving forward?
Mr. Chair, Representative Nadeau, I would have to go back and look. That was an item that had substantial administrative costs to deal with pulling that program out of the cash grant program. But it shouldn't, since the way MFIP cash grant worked, and you'll hear more about this momentarily, I probably shouldn't go into too much detail, but the people had to go into the diversionary work program first to get into the cash grant program, and now it's just going to end up being a direct path because it was judged that the diversionary work program wasn't working as effectively as people thought it should, I guess is the way I would characterize that.
Okay. So
Representative
just follow up. So then the funding for employment supports in this, that funding is just being moved over to cash grants? I mean, it's like $1,500 per person per year cap or whatever for employment services. What happened to that $1,500 per person?
Mr. Chair, Representative Nadeau, I would have to go back and look at the 23 bill to tell you that. The 23 bill pulled or sunsetted the DWP program. There were costs related to extracting that and changing the way business is done. I do not remember off the top of my head. That would just be, I mean, there's also federal fund, as I said, there's federal TANF fund that's in here, and there's also state general funds. Generally speaking, the way it goes is the TANF funds go first and the state goes second on who pays. When we extracted that part of the program, I think, but I'm not positive, the money you're talking about is just no longer expended on the purpose you were describing. And so the money wouldn't go away. It's just either part of the general fund appropriation or the TANF appropriation. But since this is forecasted, the number that is necessary to run the program changes with every forecast. So I guess I would say the money you're talking about just didn't get taken away from this committee. It's just no longer a purpose that it's going to be spent on, if that makes sense to you.
Thank
Representative
you.
Nadeau.
Thank you, Mr. Chair.
All right, thank you. I do have a question. What you mentioned FFP. What qualifies for FFP precisely, or where can we find that information?
Usually, Mr. Chair, the agency usually notifies us of that, but it is administrative dollars for FTEs at the administrative level. If you start a grant and there's an administrative portion to the grant, and so then typically that would be something that FFP would apply to. It is administration of grants and programs at the agency level, which for programs that the federal government has some interest in. It wouldn't be, if it were a state-only program, the feds would not pay. But for various programs like MFIP, where it's a partnership between state and federal dollars or other things like that. But it's typically administrative dollars. Bodies and the administration of. There's also, there's a separate thing for, the feds also participate in IT projects to some degree. We'll probably talk about that. The governor has a recommendation on the SSIS system. I don't know off the top of my head what the federal match on IT projects are, but I will be able to find that out easily.
Thank you, Mr. Berg. Yeah, that's what I was hoping to get at, is SSIS is something that we're going to talk about a lot as it goes on, and the more we can scrounge money from all sorts of sources, the better.
Actually, Mr. Chair, now that I think about it, because having read the governor's recommendation on that, they are canceling and reappropriating $10 million, and there is a reference in there to that then adding 20 million to the project itself. So the federal match, at least on that project, is assumed to be 100% of the money we're getting, or that is, the feds pay half.
Representative McDonald.
Thank you, Mr. Chair. Mr. Berg, I would assume that the federal TANF money and then our federal money as well will change and fluctuate this next biennium. Is that correct?
Mr. Chair, Representative McDonald, it's certainly possible, but we don't have anything factored in because we don't have any knowledge of what might happen. I will say the state's TANF grant, it's a block grant. TANF is a block grant, and Minnesota's TANF grant has stayed the same for quite a number of years now. I'm not sure how many, more than 6 or 7, I would say for sure. And there's nothing on the horizon yet that tells us that number would change. As I say, the federal fund, that large amount of money is almost all based on the SNAP program. And again, what the feds might do with supplemental nutrition assistance, if they change it, we will get a different number, but I'm not aware of any specific proposals yet.
Representative McDonald.
Mr. Chair, thank you. Mr. Berg, thank you.
All right, I think we're ready to continue with Ms. Pinelli.
Mr. Chair and members, I'm Danielle Pinelli from the House Research Department, and I will be going over the Economic Assistance and Employment Supports programs that were transferred from the Department of Human Services to the new Department of Children, Youth, and Families. So we can continue. The first program I'll talk about is the MFIP program. It's the Minnesota Family Investment Program. It's a state-supervised, county-administered program that's jointly funded with federal and state money. It provides income assistance to low-income families, and this is what is typically thought of as Minnesota's welfare program. The assistance includes both cash and food assistance, employment and training services, and related support services and transitional services. TANF regulations limit assistance to 60 months. However, there are a few exceptions and exemptions in our state statutes. The Department of Children, Youth, and Families is the primary executive branch agency that oversees MFIP, now been transferred from the Department of Human Services. However, it's the counties that actually do the day-to-day administration, accepting applications, determining client eligibility, contracting with local service providers, and referring clients to services. The legislature can enact provisions that go beyond the minimum federal requirements that are in the federal TANF law. However, a lot of what the legislature does is influenced by those federal requirements, especially the ones that are prerequisites to receiving the federal funding.
Could you go into slightly more detail on just that last point, like the federal requirements and what, if you can give just a random example of a state requirement that we would consider, potentially consider, just so we can have a realm of what we're looking at?
Well, for example, the 60-month time limit, Minnesota currently matches the federal 60-month.
So cold, even the heater's screaming.
Been not recognized.
Minnesota's time limit currently matches the federal 60-month time limit. There are other states that have lower limits than the 60 months.
Don't turn it off.
Thank you. Sorry about that interruption. I do have one more question. To the 60-month time limit, what are some of the exemptions? You don't have to have all of them, but an example I think would be helpful for the committee.
Mr. Chair, there are exemptions related to people, like a person in the household being ill or incapacitated or hard to employ for certain reasons.
You can continue on with your presentation. Thank you.
Thank you, Mr. Chair. This next slide shows MFIP monthly assistance and asset standards for 2025. This just shows for various family sizes, the maximum cash portion, food portion, and then the full standard of assistance. So MFIP applicants must meet an initial income test that excludes certain income items from income. But in general, a family is eligible for MFIP if their income, after all these applicable exclusions, is below the MFIP income standard for their family size. And then MFIP personal property is limited to $10,000, and that includes cash, bank accounts, liquid stocks and bonds that can be readily accessed without incurring a financial penalty, non-excluded vehicles, and the full value of business accounts that are used to pay expenses that are not related to the business. And this asset limit of $10,000 is the same as some of the other economic assistance programs that are still administered by the Department of Human Services. And sort of streamlining asset limits was an initiative that the counties brought forward back in 2015, 2016 to help simplify their administration of these programs.
Representative McDonald.
Thank you, Mr. Chair. Ms. Bernelli, if a family size has one, they have the 60-month time span. If they do have a second or a third, does that then reignite, then start over at the 60-month?
Ms. Benelli.
Mr. Chair and Representative McDonald, I believe the 60-month time limit applies to the caregiver, so it wouldn't start over again with a new addition to the family.
Representative McDonald.
Very good. Thank you, Mr. Chair.
You can continue, Ms. Benelli. Well, actually, I do have a random question just to make sure you still can't get into a gear. So you didn't mention a home, and when you see 10,000 equity, it's like a lot of people have 10,000 equity in their house. So a home is excluded, and then on the, I'm assuming, yeah. And then on the non-exempt vehicles, what's an example there?
Mr. Chair and members, a homestead is excluded from the asset limit, and for each MFIP case, one vehicle per assistance unit member age 16 or older is excluded. So, Mr. Chair, members, this next slide just shows for fiscal year 2024, the recipients and expenditures for the MFIP program. So showing number of average monthly recipients and then the federal and state expenditures. Mr. Chair, this next slide shows support services grants. These grants provide employment services to people receiving benefits from the MFIP DWP programs and the Federal Supplemental Nutrition Assistance Program. Support services are delivered through workforce centers, counties, tribes, and community agencies. The service provider evaluates the needs of each participant and develops an individualized employment plan. And these grants are also used to fund a portion of county and tribal administration costs for the MFIP and DWP programs. And as Mr. Berg mentioned, the DWP, the Diversionary Work Program, is being repealed effective March 1st, 2026. The next set of services I'm going to go over, Mr. Chair, are the nutrition services. Listed on this slide are the nutrition services that are administered by the Department of Children, Youth, and Families. The Supplemental Nutrition Assistance, or SNAP program, is a federally funded program operated by the U.S. Department of Agriculture that provides food assistance to low-income families. The MFAP program is the Minnesota Food Assistance Program, which is a state-funded program that provides food assistance to certain individuals who are not eligible for the federal SNAP benefits. The Minnesota Food Shelf Program provides funds to about 300 Minnesota food shelves around the state to help them purchase food and fund operating and administrative expenses. The Emergency Food Assistance Program is a federal program that distributes U.S. Department of Agriculture donated food commodities to individuals who use on-site meal programs, food shelves, and shelters. The American Indian Food Sovereignty Program is a program to improve access and equity to food security programs in tribal and American Indian communities. And then finally, the campus-based employment and training program for students enrolled in higher education is a program that designates higher education institutions as campus-based employment and training programs, which allows certain low-income students who attend these designated higher education institutions to receive a SNAP student exemption to make them eligible for SNAP benefits. And then finally, the last couple of programs that I'm going to go through are the Financial Capability Services programs that are administered by the Department of Children, Youth, and Families. The first is Community Action Agency grants that provide programs designed to address community needs and increase the economic security of Minnesotans. And then the Family Assets for Independence, or the FAME program, helps low-income Minnesotans increase their savings and build financial assets. This program combines matched savings accounts with personal financial education, asset-specific training, and ongoing coaching. And unless there are any further questions about that, I will turn it over to Ms. Sunderman to go over child support next.
We do have a couple member questions here. We'll start with Representative Zalesnikar.
Thank you. Thank you, Chair, and thank you, Ms. Pinelli. My question is regarding what the income limits are for the classifications to receive the cash and the food portion? Are there, you talk about the asset limits, but is there income, specific infant or income limits that go with the family size?
Ms. Pinelli.
Mr. Chair and members, in general, for the federal SNAP program in Minnesota, the income limit is, I believe, 165% of the federal poverty guidelines. And then for the MFIT program in Minnesota, basically, a family is eligible if their income after any applicable deductions are made is below the MFIP income standard for a family of like size. And I believe right now in 2025, for a family of three, as an example, that limit is $1,533 per month.
Representative Zalesnikar?
Thank you, Chair. And is this income that's allowed adjusted annually for the amount that an employee can make?
Ms. Pinelli.
Mr. Chair, yes, these limits are adjusted on an annual basis. And also, I should say, in the federal TANF regulations, a person, in order to receive TANF benefits, has to have an income of less than 200% of the federal poverty guidelines.
Representative Zalesnikar.
No further questions, thank you.
Representative Nadeau.
Thank you, Mr. Chair, and I'm sorry, I'm going to take you back to the DWP thing one more time. So we repealed the requirement, and I'm asking this, did we repeal the requirement that MFIP theoretically qualified people no longer had to go to a workforce center, go through the training in order to get food supports?
Ms. Pinelli.
Mr. Chair and Representative Nadeau, no, the work requirements are still in place under MFIP. Those haven't changed.
Okay.
What we did was we're in March of 2026, the state will be eliminating the diversionary work program, which was a program that when people initially applied for MFIP, in most cases, they're being diverted to the DWP program, which is a time-limited, it's a 4-month-long program to try to get people jobs as quickly as possible. But I think in many cases, the people who are applying for MFIP now need more than just this time-limited 4 months of assistance. And so they're ending up on MFIP anyway after the 4 months. And so I think the feeling among counties and some of the advocacy groups was that it was a lot of administrative burden to run this program, and they weren't seeing a lot of value.
Okay.
Representative Nadeau.
And thank you, and I think I was getting a little confused between DWP, which the population was that higher, let's say the Ford plant, closed, and DWP was a huge component to try to get those people retrained and quickly put into. That's the population that we're talking about with DWP.
Yes.
If that's, so with that being said, so just to make sure that families that are entering MFIP still have a work requirement, and that's federal, that's the old PWORA thing or whatever, correct? That hasn't changed.
Ms. Pinelli.
Representative Nadeau, Mr. Chair, that's correct. We still have the same work requirement under MFIP as before. That wasn't changed as part of getting rid of DWP.
Okay, thank you so much. Thank you, Mr. Chair.
All right, Mr. Chair and members, I'm Sarah Sunderman from House Research, and I'll start discussing child support. First, I do want to start by saying child support is part of this committee's jurisdiction, but most of the bills on child support will also likely go through the Civil Law Judiciary Committee. And this is because DCYF, formerly DHS, is designated as the state authority to receive and sort of handle the funds that are then distributed to child support recipients, but the processes are all court-based, essentially. So both committees will see child support bills. So federal law requires each state to establish a child support enforcement program and sets broad standards and requirements that Minnesota meets. And then the federal government provides TANF and child support enforcement funding to states with child support systems that meet those requirements. DCYF is the public authority responsible for oversight of the child support system in Minnesota, which counties administer, much like many other programs in the DCYF and HHS space. And I believe the federal match is 66% of county and state child support enforcement spending. This is a very high-level overview of child support, but essentially, child support includes basic support, medical support, and work or education-related child care support. Basic support is the amount that's intended to cover the costs of the child's housing, clothing, food, education, and other necessities. A parent's basic support obligation is calculated based on parental gross income. This can get very complex, especially with deductions and exclusions, and the resulting amount is what's called the parental income for child support, or the PICS. The PICS for both parents is then combined, and the court determines each parent's percentage share, and then compares the combined basic support obligation to the child support guidelines, which are found in statute. The court may deviate from the guidelines and statutes, and if they do deviate, they have to make written findings stating the reasons for the deviation, and the deviation must always be in the best interest of the child. There are 2 publications on the House Research website, one of which is either just updated or will be updated very soon. They both go into this in much more detail than this presentation, because each circumstance is very different. And the judicial branch also publishes a lot of helpful materials on child support. Moving next to child support enforcement, there are a range of mechanisms in Minnesota statute to enforce child support orders. Income withholding is by far the most common one used. There are parent locator services, the work reporting system. There's also the ability to, for the court to issue licensing sanctions and suspensions, which includes driver's licenses, occupational licenses, and recreational licenses. There can also be liens and civil judgments against an obligor, tax refund intercepts, and criminal charges. The majority, like I said, of child support was collected through income withholding. So that it was about $369 million of the $510 million collected and dispersed in 2024. And in fiscal year 2024, for every $1 spent by DCYF, they collected $2.65 in child support. And DCYF publishes an annual child support performance report on their website, which has a lot of very useful information on the enforcement process and the financial side of it. If there aren't any questions, I'll move to child welfare and placement. Similarly to child support and many other programs in this committee's jurisdiction, federal law requires each state to provide intervention and services to protect children from abuse and neglect. And the legislature establishes the policy to implement federal law and provide services to families. Most of the provisions related to child protection are found in Minnesota statutes, chapters 260E, which is the Maltreatment of Minors Act, and chapter 260C, which is more about children in need of protection or services and the placement processes. And funding for these services comes from federal, county, and state sources combined. First, moving to the reporting of maltreatment of minors. As I said, this is found in Chapter 260E. Maltreatment in Minnesota statutes is defined as egregious harm, neglect, physical abuse, sexual abuse, substantial child endangerment, threatened injury, mental injury, and child maltreatment in a facility. These terms are individually defined in statute in this chapter as well. Any person may voluntarily report known or suspected child maltreatment, but there are certain individuals who are known as mandatory reporters who must report suspected or known maltreatment in the preceding 3 years to the local welfare agency or applicable law enforcement or other responsible agency. And mandatory reporters include professional or professionals delegates in the healing arts, social services, hospital administration, psychological or psychiatric treatment, childcare, education, correctional supervision, probation or corrections, or law enforcement. Also, members of the clergy who receive the information through ministerial duties. And fairly recently, we added employees or supervisors of public or private youth recreation programs. And the circumstances for which they need to report are specified in statute. Moving to the response when a report of child maltreatment is alleged. Counties provide response services when a child is alleged to have been maltreated in the home through either the family assessment path or the family investigation path, depending on the allegations. Law enforcement investigates reports that allege criminal violations along with county agencies. And then when a caregiver outside of the home is alleged to have maltreated a child, the responsible agency conducts the investigation. In schools, that is MDE. For foster care, family child care, and other legally non-licensed child care providers, that is the county social services agency. Facilities licensed by DHS. DHS is the designated agency. And similarly, facilities licensed by DCYF or MDH have the responsible agency accordingly, would be DCYF and MDH. So sort of moving along in the process after the report and the response to the report, if a child is found to be not safe in a home or the parent has not cooperated with a service plan, a county may then file a child in need of protection or services case, otherwise known as a CHIPS case. The child is then placed in foster care, and the case plan is developed to attempt to reunify the family within 6 to 12 months. And there are review hearings every 3 months. There are limited circumstances under which the county attorney can file a permanency petition in a more expedited manner, and those can be found under Section 260C.503. In a CHIPS case, if the home remains unsafe after the child is in foster care for 11 months, the county will file a permanency petition. Typically, this could be a termination of parental rights petition and adoption. It can also be guardianship to the Commissioner of Human Services, otherwise known as adoption with parental consent, or a transfer of permanent legal and physical custody to a relative, commonly referred to as a kinship placement. Reunification may also be a permanency option if the court determines that the home is safe and reunifying with the family is in the child's best interests. And in statute, the court decisions must always be governed by the best interests of the child. Finally, moving to North Star Care for Children, it's, as Mr. Berg mentioned, a forecasted program that provides monthly assistance payments for children in foster care and to children who are adopted or whose custody is transferred to a relative in a kinship placement. Payments are based on age, and then supplemental payments are based on the child's assessed special needs. Kinship or adoption assistance eligibility is determined by initially county or tribal staff with a final determination by DCYF. To be eligible for North Star payments, there are general eligibility requirements such as citizenship and background studies and a permanency setting. But for foster care, a child must live with a foster parent who is licensed or in the process of getting licensed for up to 6 months. And then for kinship and adoption assistance, there are also, for adoption assistance, there needs to be a special needs determination, and there are, the kinship assistance, a child must live with the prospective custodian for, who is licensed as a foster parent for 6 consecutive months leading up to the placement. And with that, I will hand it over to Ms. Mock to discuss childcare licensing, unless there are any questions.
Representative Nadeau.
Thank you, Mr. Chair. And just one question on the North Star Care for Children, on the supplemental payments. Who adjudicates that? Is that like the child's guard? Is it through the court system? Or is that by design in statute or in rules? Where does that come from?
Ms. Underman.
Mr. Chair and members, the North Star requirements are found in statute. Initially, the determination is made by the county or tribal staff, whether a child has special needs in order to receive North Star payments, and then the ultimate determination is by DCYF. The courts are not involved in deciding North Star payments.
Representative Nadeau.
Thank you.
Ms. Mock. Very
thank-
cool name.
Thank you, Mr. Chair. I'm going to start by talking about childcare licensing, and I'm going to specifically be talking about state licensure. Indian tribes also license childcare programs in the state, but I'm going to be talking about the requirements and processes with state licensure. So just as an overview, any individual, corporation, or organization that provides childcare services in the state has to either be licensed or explicitly excluded from licensure. So you're probably familiar with the primary license types that are available. So there are childcare centers, which are generally located in non-residential settings, and that are bigger programs that have multiple providers providing care. There's family or group family childcare providers. They're typically located in residential settings with only 1 or 2 providers of care with smaller groups of children. And then there are also special family childcare homes, which you've probably heard referred to as the pod model. This is where a non-residential setting, like, for example, like a church basement or something, hosts multiple family childcare providers sort of co-located in the same space. So those are the 3 different license types. Any program that isn't one of those license type has to be explicitly excluded from licensure in order to care for children. There is a list in statute of programs that are excluded from licensure. They include things like before and after school care for school-age children that takes place at public schools. Also what's called family, friend, and neighbor care, which pretty much is exactly what it sounds like. It's like if grandma is caring for her grandchildren 2 mornings a week, that type of an arrangement is excluded from licensure. There are also, just to make things a little bit confusing, there are license programs, there are programs that are license exempt, and then there are programs that are license exempt but get additional certifications in order to accept CCAP. Which is a child care subsidy that I'll talk about in a few minutes. So there's really generally sort of 3 categories of child care programs in the state. So all the licensing duties are split between both state and county agencies. The state agency, which I should have noted at the beginning, child care licensing is moving to DCYF. However, it is still administered by DHS. It's not expected to move to DCYF until June of this year. So the state agency responsibilities currently under DHS, they issue the licenses, they conduct all the background studies that are required for all the staff at the child care programs. They impose the sanctions on the programs that are not in compliance, And they also perform specified licensing functions specifically for childcare centers. So that includes things like conducting the annual inspection that childcare centers have to have. They also have a role in monitoring and enforcing all the statutes and rules. The county agencies, they perform specified licensing functions for family childcare providers, so they'll do the annual licensing inspection for family childcare providers, and they also play a role in monitoring and enforcing statutes and rules. You've probably heard a lot about efforts to update childcare licensing requirements. The 2021 legislature directed DHS to contract with an organization to develop new licensing models for childcare centers and family childcare providers in the state. There's a lot on the DHS website you can find about sort of what that contract looked like and the work that was done with the contractor. I'm just going to briefly talk about the 3 expected outputs of this work and sort of what their status is right now. So the first output, you can see in that first row of the table there, is to develop and implement what's called a weighted risk system. So this is a tiered enforcement framework under which violations of statute and rules are assigned enforcement actions based on the risk the violation poses. So if it's a low-risk violation, there should be a smaller enforcement action. If it's a higher-risk violation, the enforcement action should be stronger. This weighted risk system is actually already currently in statute. It was put into statute last session. But as I understand it, it is not currently in effect. My understanding is that it won't be effective. DHS won't start using it until another initiative called the Provider Hub is fully implemented for childcare providers. Since I just,
Excuse me, quick question on that weighted risk system. So you mentioned it's not in effect right now. So under the current system, is it the same penalty for basically every violation, or is it just individually listed what the penalties are, what violation?
it's not quite the same penalty for every violation. They do take into account sort of the different types of violation, but it's much more even than what they're proposing under the weighted risk system. So it'll be a more nuanced system.
Representative Zalesnikar.
Thank you, Chair, and thank you, Ms. Mick. My question is regarding the penalties. Do we have data on the amount of the fines for the state licensed providers for childcare versus the county licensed providers?
Ms. Mock.
Thank you, Mr. Chair. Representative Zalesnikar. No, I do not have any data. I was not able to find any recent data from DHS about either licensing or when we get to it, actually CCAP penalties either.
Representative Zalesnikar.
Thank you, Chair, and thank you. That would be something I would like to see. I think this committee should see the actual scope of licensing penalties, the scope, the severity, and the fine amount by county would be great for this committee to see so that we can see the amount of fines and the actual penalties under the current standard until this provider hub is done, to have a scope of assessment of what the landscape looks like currently for our center-based childcare, our family-based childcare, and then I don't believe there would be any for school-based programs.
Ms. Mock.
Thank you, Mr. Chair. You're right that there wouldn't be any necessarily for school-based, as those programs don't have to be licensed. But yes, that is information that I know in previous years the agency has been able to provide to committee, so I'm happy to ask for that and follow up with the committee.
I do have another question on the background, on the background study. Something I've heard talking with a lot of providers is it's not a lot of information that at least the provider gets to see. Could you just go into a little more detail on what the background study is looking for and how that appears when they're saying approved or denied to the provider asking for it?
I'm going to have Ms. Sunderman take that one.
Ms. Sunderman.
Mr. Chair and members, so the DHS background studies, I would recommend looking at Chapter 245C in statute, and I believe it's 245C.15 that lists all of the disqualifications, the disqualifying crimes for all DHS providers, including childcare providers. As far as what the employer gets to see, I don't know that information. I think the net study system searches a wide range of records to find the disqualifying crimes or conduct. And I don't know how much the actual employer gets to see as far as whether someone is disqualified or not disqualified. I don't know off the top of my head whether they get to see what the disqualifying crimes were specifically. The department would have that information, and if they are allowed to under statute, they can do a reconsideration if it is requested by the individual and grant a variance or a set aside, but that's very case by case. So it's a very long list of disqualifying crimes or conduct, if that's helpful.
Citing a statute for us to look up is a very good answer to a question, because we should do our homework too. It's my understanding that they just get a thumbs up or thumbs down and they go with it. That's been a concern when an abuse case shows up. The centers, well, we had no idea. They said it was fine. And then they discover some sort of history, but that didn't rise to the level of a disqualification. And in many other states, some states are incredibly aggressive in what they turn over. We seem to be way under, and that's a very important issue to me, is particularly on abuse in these settings, is how can we help these providers navigate and get the right people for the job, because it is a hard job that doesn't pay very well, but it seems that we don't give them the tools to make a selection other than a thumbs up or thumbs down. So I am very excited to really dig into that. Any more questions before we move on? Representative McDonald.
Thank you, Mr. Chair. Question for Ms. Mock. Representative Nadeau and I were visiting with the Wright County Commissioners regarding the licensing for the daycare providers, and they mentioned something about the renewing of their licensing with fingerprinting and the complexities that ensue because of that, and the lack of places to be able to renew, therefore filling a void where they can renew their license and therefore not take on children. I just want to, the question is, what can we do to solve that problem? And can you give a little more clarity to that issue, if you have it?
Ms. Sunderman.
Mr. Chair and members, this is related to the background studies under Net Study 2.0, which requires fingerprints and photograph. This is done at one of the vendor locations across the state. It is my understanding that they're called IDEMIA. The company is IDEMIA, and it's my understanding, and I did look at this fairly recently on the website, there are fingerprint and photograph locations across the state. I believe there aren't any, you can be anywhere in the state and be roughly 40 miles from an IDEMIA location. And on the website, there is a pretty useful map with all of the vendor locations across the state. Now, I don't know about the hours, the open hours at each individual location or anything like that, but again, this would be, DHS works with this vendor to get the fingerprints and photographs done for the background studies.
Representative McDonald.
Thank you, Mr. Chair. Representative Nadeau, this is something we probably need to work on, just because we heard firsthand from the commissioners at the county that it is an issue, and it's leaving a void in these daycare providers being able to be renewed of their license, and therefore their parents, of course, are left hostages, if you will, not being able to drop their kids off. So with 40 sites, that doesn't seem to be enough really to help that issue, Mr. Chair.
I believe she said you can be anywhere in Minnesota and be 40 miles from a site. Not that there were only 40 sites?
Yes, there are more
Yes,
than 40.
Mr. Chair, thank you, yeah, for that clarification. Representative Nadeau, do you have anything to add to that problem that we heard?
Only that, and thank you, and Mr. Chair, I did have a meeting with the with DHS on this. And there is going to be a new RFP that they're going to put out. They made a valiant argument about how important it is that there be connections. I talked specifically about why can't we use law enforcement to do fingerprinting component, and that's only one part of it. And so they were going to get back to me with some more information on, how we could increase access, if there's ways that we could incorporate law enforcement to do some of these things. It didn't seem like they were super enthusiastic about that. And Net Study is a pretty robust, it's a pretty robust background mining piece of software. And it's not very common that people have to be re-fingerprinted unless it's a certain level of clearance. So normally, that's just constantly mining data, and finding out if something comes up in a future background. Direct service providers that use it, be it childcare or direct service providers for people with disabilities, they don't normally have to go and do it again ever, is what my understanding is. And I could be wrong, but that's what I understood. Thank you, Mr. Chair.
Yes, thank you, Mr. Chair, for indulging me, and Mr. Nadeau, or Representative Nadeau. Yeah, 40 miles, I stand corrected, right? I just misspoke on that, so. Well, that's something for this committee that we continue to look in when we are boots on the ground and hear it from our county commissioners and daycare providers, and something we can hopefully fix. Mr. Chair?
Representative Zalesnikar.
Thank you, Chair, and thank you for the information. My understanding is that too, within Idemnia is the same system that long-term care, assisted livings use in the state with Net Study. The concern I'm hearing is the hours that are available are 2-hour blocks, sometimes 4-hour blocks, and the pathway then for people to have employment and for providers to have the employee roster complete in order to serve the children in childcare or the elderly is a barrier with this current system that we have right now. And there have been times, I know in the Duluth area, that there were 0 providers recently, and so it's back up. But people were driving from Duluth to Moose Lake or going into Wisconsin. And so we need to make sure that, and I'm glad that my colleague Representative Nadeau has met with DHS to look at streamlining this in a way with a new RFP where we have people entering the workforce and we can get these requirements completed timely and have it efficient for people so they're not driving as far, because the reality is people can surely get a job in their community without driving 40 miles for the first step to even be a consideration. So I think this fingerprinting situation is an important thing for this committee to address this session. It's been an ongoing issue for a long time in healthcare, and it's clearly one in childcare too, 2 really critical pillars. So I look forward to a deep dive on fingerprinting and Net Study and the whole process. Thank you.
I have one extra question while we were talking on the enforcement, the weighted enforcement system that is being considered. Is there information on what like the peak penalty would be? Maybe not the crime or whatever we're talking about, but the penalty that is suffered compared to what the top end penalty that we currently use. As you mentioned, it was more severe, so I'm curious what the range is there.
Thank you, Mr. Chair. As far as I know, there's currently not a lot of information. Statute the statutory, where it is in statute sort of outlines the program, but leaves a lot to DHS or DCYF to actually make determinations in implementing it. And as far as I know, they haven't produced any additional information about how they would implement the system.
I believe we're ready to continue.
All right, thank you, Mr. Chair. I will continue with the next 2 outputs from these modernization efforts. So in the middle row of that table, DHS was directed to develop and propose revised licensing standards for both child care centers and family child care providers. This has to do with reworking the statute and the rules that set all the standards for childcare licensing in the state. This is probably the most high-profile output from this work. Last spring, DHS issued revised licensing standards and then spent a few months collecting feedback from individuals, advocates, childcare providers on those standards. My understanding is that they are going to issue revised standards sometime this year, and then they expect to have a proposal for the 2026 legislature to consider. The final output is to develop and implement what's referred to as a key indicator system for abbreviated inspections. So under this system, a child care provider can qualify for a shorter annual inspection that is focused on a subset of standards that statistically predict compliance with the larger set of standards. So the idea is a shorter, more targeted annual inspection. And this is another one that my understanding is they haven't implemented yet, and they expect to implement once that provider hub is up and running for all child care providers.
Question on existing inspections. So would the provider be made aware of their annual visit before it happens?
My understanding is yes, they are made aware of the visit before it happens. All right, I'm going to move away from childcare licensing and just talk briefly about Parent Aware. Parent Aware is the state's voluntary quality rating and improvement system for childcare programs. A quality rating and improvement system is intended as a way for a state to assess and communicate the level of quality in the state's early care and learning programs. Most states do have quality rating and improvement systems in place, and most, like Minnesota, the program is voluntary, so providers can choose whether or not to participate. If they do choose to participate, there are some financial incentives for them to do so, like they can get a higher CCAP subsidy if they participate and reach a certain star level. But then they are, when they choose to participate, they can be rated between 1 and 4 stars. Beginning in 2026, an automatic 1-star rating system is set to go into effect for all childcare programs that are in good standing and that do not explicitly opt out of the program. That will likely be a very big change in the program, because as you can see on the last bullet in this slide, currently only about 1/3 of childcare programs in the state choose to participate. So once that automatic rating goes into effect, that number will obviously look very different. I should say that the share of childcare providers that choose to participate varies widely by type of provider. So you can see on the slide there that just over half of childcare centers choose to participate in Parent Aware, but it's only about 17% of licensed family childcare providers that choose to participate. I didn't include the numbers for Head Start programs and school-based, like pre-kindergarten programs, but those programs, it's up in like the 95% of those programs choose to participate. And with that, I'm going to move on to talk about subsidies for childcare. So these are financial assistance to low-income families to help them pay for the cost of the childcare of their choosing. We have 2 programs in the state that provide subsidies. We have the Child Care Assistance Program, or CCAP, and we also have Early Learning Scholarships. So I'll start with the Child Care Assistance Program. This is a federal-state program that, like I said, subsidizes the child care costs for low-income eligible families. When I say federal-state, like the MFIP program that Ms. Pinelli talked about, this is a program that the state administers within broad federal guidelines, and the state has to comply with the federal guidelines in order to receive the federal funding for the program. You can see the eligibility criteria there on the slide. Parents have to work or participate in education or training activities in order to receive CCAP subsidies. Household income needs to be less than or equal to 47 or 67% of state median income, and that's between $59,000 and $84,000 a year for a family of 4. And the children have to be under the age of 13 or 15 if they have a disability. Just to give you a sense of the scope of the program, there's program statistics there for fiscal year 2024. There were about 12,000 families enrolled in the program each month. The general rule of thumb is that there's twice as many children enrolled in the program as there are families, so 24,000 children. Each family received about just a little over $2,000 each month, and total spending, that's federal, state, and county, was about $306 million. For childcare providers, they can choose whether or not they want to accept CCAP payments. If they want to, they have to either be licensed or, as I talked about earlier, they have to be a certified or a legal non-licensed childcare provider. The counties are actually responsible for reimbursing the childcare providers according to rates that are set in statute. And those rates are based on a survey of childcare prices that's conducted every 3 years. The current standard maximum rate is the 75th percentile of the most recent survey. And I said that like there was one rate, but there are actually tons and tons of rates because the rates vary by county, by childcare provider type, and the child's age. And as I mentioned earlier, providers can receive increased rates under CCAP for either having an accreditation or having a 3 or 4-star parent aware rating. Statute does give DCYF or DHS the authority to investigate alleged or suspected financial misconduct by providers and any payment errors that they might find. And there's a whole bunch of processes outlined in statute for conducting those investigations. Historically, historically is not quite the right word here. What I mean to convey here is that currently the program integrity functions are still being conducted by DHS. So these are the functions that DHS employs for CCAP and other licensing efforts. I would expect that most of these will just move to DCYF when these functions move to DCYF, but obviously I can't know that. But the way that DHS has been working on program integrity is they have what's called an early and often team, which is where licensors and child care investigators work closely with applicants or newly licensed programs to make sure that they're in compliance with licensing requirements. They also have a team that audits, that conducts compliance checks and audits of programs that receive any sort of grants. And then specific to CCAP, there's a unit that investigates whether programs are in compliance with CCAP or whether they're in violation of CCAP requirements. And that unit has the authority to take action if they find a violation, either through administrative remedies or by making a referral to a local law enforcement agency. And as I mentioned earlier in an answer to a question, I was not able to find any recent statistics on program integrity from DHS, but that's certainly something I can follow up with the agency on. Finally, I just want to mention, I know we've been talking a long time, so I'll just quickly mention that, as I said earlier, CCAP is a federal-state program. When federal rules change, the CCAP program has to change in Minnesota. And the federal government did issue new rules for the CCAP program last March, and the states have 2 years to come into compliance with those rules. There are quite a few changes. Some are small, some are big. Some of the bigger ones there are listed on the slide. States are going to be required to cap family co-payments for the CCAP program at 7% of family income. Currently, the state has co-payments up to 14% of family income. States are also going to have to start paying child care providers who accept CCAP in advance of services or at the beginning of the provision of services. Currently, Minnesota, like a lot of other states, pays the child care providers retroactively. And then states are also going to have to use some grants and contracts as a way to pay child care providers for specified populations, including infants and toddlers, children with disabilities, and children in underserved geographic areas. States are allowed under the federal law to use some federal funding to come into compliance with these requirements, but there are limitations on how much federal funding they can use. And I haven't spent a lot of time with the governor's budget recommendations yet, but I did notice there are several recommendations related to coming into compliance or having CCAP come into compliance with these requirements.
Are these changes you just mentioned, is it that from an agency or was that a federal law that was passed?
It was actually from the agency. It was a revision to regulations. Next, I'll talk about the other subsidy program, which is Early Learning Scholarship Program. This is a program that was previously administered by MDE, but has now moved over to DCYF. This is a state program that subsidizes childcare costs for low-income eligible families. I said almost those same words when I described CCAP. The programs are very similar. One of the biggest differences, though, is that this is a state-only program, so no federal requirements. You can see the eligibility criteria there on the slide. A family has to have household income below 47% of the state median income, which is about $59,000 for a family of 4. Or they have to be able to document their participation in a specified public assistance program like free and reduced price lunch or MFIP. Or they can have a child in need of protection services or placed in foster care. The children who are eligible for scholarships have to be under the age of 5 years old. So that is different than CCAP, where eligibility was up to 13 or 15 years old. The subsidies for early learning scholarships used to be just based on the childcare program's parent aware ranking, but that has changed in recent years. And now the subsidies are based on the age of the child who's receiving the subsidy, the geographic location of the childcare provider, the parent aware ranking, and also the type of childcare program that's providing the services. That sounds probably very similar to CCAP, and it is. And so now the subsidies under the scholarship program look much more similar to CCAP subsidies. There are two types of scholarships. There's Pathway 1 scholarships, which are awarded directly to eligible families, that then the families can use at whatever childcare program they choose, which is very much like CCAP. But there's another pathway, Pathway 2, where the scholarships are awarded directly to childcare programs that have a 4-star parent aware rating. And then those programs have to use the money to create seats for children who are eligible for scholarships. There's program statistics here on the slide for fiscal year '23. You can see there's just over 12,000 children who received scholarships that year. Just over half of them were Pathway 1 scholarships. And the state funding that went to the program was about just over $82 million. I should note that the 2023 legislature made a lot of changes to the scholarship program, a lot of which I've described here, but they also greatly increased the funding for the program. So it went from about $70.7 million in fiscal year '23 up to $196 million in fiscal year '24. So when we have the fiscal year '24 program statistics, they're likely to look pretty different. All right, I am going to briefly talk about a few
We
early
got a
learning.
question really quick.
Sorry.
Representative McDonald.
Mr. Chair, thank you. Ms. Mock, a question regarding the early childhood scholarships, the pathways, and some of those monies going to the programs. The recent news the last couple of months with the fraud case in St. Cloud, do you know if that organization was eligible for the scholarship monies?
Ms. Mock.
Thank you, Mr. Chair. Representative McDonald, I do not know. That is certainly something I could ask the agency about, but I do not know.
Representative McDonald.
Mr. Chair, I would imagine that this committee will probably want to ask a lot of questions regarding that fraudulent case of taxpayers' money being stolen by this. There was, I think, was it 2 sites in St. Cloud, I believe, 2 or 3? And of course, we're dealing with, you know, what they had the last, in 2023, $100 and some million that was allocated for the programs. So would you folks then get involved and help us with finding out some of the details, whether they got the money or not?
Ms. Mock.
Thank you, Mr. Chair. Representative McDonald, we can certainly ask the agency. I don't know that we have any ability beyond that to find the information.
Thank you. Yeah, we'll certainly ask the agency as well. Yeah. Thank you.
Representative Zeleznikar.
Thank you, Chair. And I have a quick question. My question is back on page 34 on the parent aware. There seems to be a great discrepancy between licensed child care centers and the family providers that choose to enroll in the parent aware, which is interesting. And I guess my question is, my understanding is that the 33-month-olds that go to the school-based program, they have an automatic 4-star. And so I'm curious if that application process for the 4 stars matches the same requirements for application for the centers and the family childcare.
Ms. Mock.
Thank you, Mr. Chair. Representative Zeleznikar. So there are different rating pathways under Parent Aware, and different types of programs are eligible for the different pathways. So you're correct that Head Start programs and school-based pre-kindergarten programs are eligible for the automatic rating pathway, where they are, I think with just submission of information basic information about the program, they receive an automatic 4-star rating. Family child care providers are not eligible for that pathway. So they would have a different application process for Parent Aware.
Representative Zeleznikar.
Thank you, Chair. So it's possible that the pathway, the timeliness for the pathway, completion for this application to complete, to get the 4 stars could be limiting the abilities for childcare centers, administrative time, or for a single-family owner who's providing childcare, the time it would be required. It could be limiting them from being eligible to complete this pathway 4-star model.
Thank you, Mr. Chair. Representative Zalesnikar. I think that's right. I know in some surveys of family child care providers and their trying to learn about their experiences with Parent Aware, one of the complaints from family child care providers is the amount of time and paperwork it takes to get rated.
Representative Zalesnikar?
No further questions. Thank you.
Ms. Mock?
Thank you, Mr. Chair. It's just going to take me a second to remember where I was. I was going to talk about early learning programs. Again, so these are programs that were previously with MDE. They have transferred to DCYF. Huge caveat here. My understanding is that most of these programs are not under this committee's jurisdiction. They are going to be under the jurisdiction of the education committees. My understanding is that Head Start and Early Head Start are still under this committee's jurisdiction. So I'll talk a little bit more about those, and I'll only mention the other ones. Head Start and Early Head Start are federal programs that provide comprehensive family-oriented services to children from low-income families. The state does appropriate money for Head Start, but the majority of the funding for the program is federal, and all of the rules surrounding the program come from the federal government. There isn't a huge state rule other than with that appropriation and how the appropriation from the state is used in the program. You can see enrollment in Head Start is just under 12,000 here in fiscal year 2025. Most of that enrollment is in actual Head Start, which is for 3 to 5-year-olds, but there are 3,500 children in Early Head Start, which is for children from birth up through age 2. And then the other programs I'll just mention, again, these are programs that used to be at MDE. They are now being administered by DCYF, and my understanding is they are in the Education Committee's jurisdiction. Those programs are voluntary pre-kindergarten, school readiness, early childhood family education, or ECFE, and then developmental screening. If there aren't any questions, I'll keep moving. This is the last section, so we're almost done. I'm just going to briefly talk about some programs that support the child care workforce. So the biggest one is the Great Start Compensation Support Payment Program, and I mean biggest both in terms of the appropriation to the program and the number of providers who receive grants under the program. This is a program that provides monthly payments to child care programs that then those child care programs are supposed to use to fund increases in compensation and benefits for child care workers. It's an ongoing program, and under the program, there are ongoing payments available to licensed child care providers. That's both licensed centers and licensed family child care providers, and then also to the certified child care programs. And then there are one-time payments that are available for legal non-licensed providers. This program was established by the 2023 legislature, although it's pretty similar to programs that were established in previous years back to fiscal year 2020. The payments amount under the program are based on a program's FTEs with a set amount of money per FTE. And that set amount of money currently and through June of 2026 is $375. DCYF recently issued a report on the first year of the program, and these are all numbers from that report. You can see on the left side of the table, you can see the different provider types, and then as you move across the table, you can see the number of providers that received payments under the program in this first year, the average FTEs each program had, the average payment that went to each program, and then the total payments. And if you look down in the bottom right-hand corner, you can see that $141.8 million went out the door in these payments in the first year of the program.
Is the average payment column, what time period is that?
It's for the time, it's a monthly payment. And I'm just going to quickly go through a few additional programs. So there are retained bonuses available to child care workers. These are available to workers who meet specified qualifications in terms of working to earn higher qualifications. And they also had to get this bonus, have to commit to working in the field for at least 1 year after receiving a bonus. So the goal here is really to keep people in the field. There are teach scholarships available. These are available to childcare workers who want to take classes to earn college credit or an associate's or bachelor's degree. There's also an apprenticeship grant program that actually works with the teach scholarships. So individuals who do receive teach scholarships may be also eligible for the apprenticeship program, where they could have a mentor and an employer work with them, and then that mentor and employer would also receive stipends under the program. Finally, there are family, friend, and neighbor grants available. So just as a reminder, family, friend, and neighbor providers are those providers who are license exempt and just providing care to either relative children or children from one unrelated family. There are grants that go to various organizations, and those organizations then use that grant money to directly support family, friend, and neighbor caregivers, either with like help with training or giving them education about licensing or subsidy programs. And then finally, there are grants for Grow Your Own Early Childhood and Family Educator programs. These are available, again, to various organizations that then are supposed to host or build or expand an early childhood educator preparation program. With that, we have a slide with a few resources. There's HRD publications. There's also a link to the Fiscal Analyst Department's website, and also a link to DCYF's website. And then you have all of our contact information. And that is our overview, Mr. Chair.
Is there any questions at the very end here? Well, my recommendation to all members of the committee would be, if you have a question while you work on legislation, try and find it yourself before bothering our staff. They are here to be bothered, but they are very busy people. That is why they give us good resources, so we can do some work ourselves and make sure we are learning and not just depending on them to tell us everything. One thing I forgot to go over at the very beginning is our committee rules. They're very similar to every other committee rule. Really, the only substantial difference from the last committee is instead of 24 hours, we're doing 8 a.m. the day of for amendments and other things. That can be changed if we're going to run into a disaster with nonpartisan staff trying to keep up with it. Also, if you have any bills with a legislatively directed grant to a nonprofit, that bill, in order to be heard in this committee, will be required to submit their 990 so that the committee knows exactly what organization and what their funding looks like when we're considering funds to them. That was a recommendation from the legislative auditor and seems like a good practice that I know other committees follow, but I would like to bring that here since we do like to deal in grants. Next week, well, tomorrow, we have another hearing on expert input from actual childcare providers and those who represent those providers on existing regulations that are driving up costs. We just heard about the boatloads of money that we spend on childcare, and childcare is still outrageously expensive. We're averaging $20,000 for an infant in a center right now, which is just unsustainable. When you heard about all these grant programs where you have a family of 4 needs to make $84,000 or less, when you're paying $24,000 a year, you could be making much more than that, and be in tough straits. These are issues are gonna be expensive, and we've got to be creative in how we address them. But we can't just be focusing on one side of childcare. This presentation was fantastic. Really appreciate the time you guys spent putting it together. I hope you are able to keep your workloads reasonable until we are unreasonable and torture you the last several months of session. But with that, is there anything I need to cover? Well, with that, well, we don't need to. We are adjourned.